So researchers at the Africa Criminal Justice Reform Unit say the National Prosecuting Authority's performance should not only be measured based on conviction rates. The team says data shows that only half of South Africans feel safe when walking during the day. They say the NPA's conviction rate of above 90% helps to mask other realities. Let's talk about this some more. We're joined now by Professor Muntingh from the Africa Criminal Justice Reform, who worked on this paper. Prof, good to have your time tonight on eNCA. So why shouldn't the NPA's conviction rate be our main measure of its success?
Good evening. Well, the first point is that if we look at the overall numbers of people from the total number of arrested to cases enrolled, cases prosecuted and ultimately convicted, we see a massive attrition rate. So roughly from about 1.7 million arrests to about 300,000 cases annually finalized by the NPA, and then a large proportion of that are guilty pleas as well. So to say that we have a 90% conviction rate really refers to a very small percentage or very small number of cases that are successfully prosecuted. So the chances of that having an impact on especially repeat violent offenders that are responsible for a disproportionate amount of crime, the chances of that having an impact is almost nil. And so we must look at it broader.
And when you say, Prof, that the NPA is not prosecuting cases in some instances with an 80% chance of success, talk more about those cases and why there is a decision not to prosecute when it appears so strong.
Well, there's over time there's this tradition of pursuing a very high conviction rate, and it creates a perverse incentive. And we've actually seen over time a reduction in the actual number of cases being prosecuted. And that does not bode well for trust in the criminal justice system. And we should also not only look at the conviction rate, but also the type of cases that are pursued. I think one must also be quick to add that there's one category of offences where there's been a slight improvement in terms of the volume of cases and the success rate, and that is the sexual offences. And I think one must be grateful for that and learn from that and see how one can apply those lessons learned to other sectors as well.
Interesting that you bring up the issue of sexual offences, because it then ties in with another concern that you flagged, this about cases that are resolved through informal mediation. Now, you flagged a concern about cases that involved young people, and I wondered if these were cases, A, where young people were the perpetrators or the victims, and why it was that there was a leaning towards informal mediation in those instances.
There's in principle nothing wrong with informal mediation, and we see this, for example, in the child justice sector, where it is not always in the best interest of the parties, in particular the child, to pursue a criminal prosecution. However, our concern here is that it is entirely unregulated, and so there isn't really a record of the parties involved, whether this is the first, second, or third time that this person has, so to speak, escaped prosecution because there was informal mediation and so on. And so, for example, let's say you have a person charged with sexual harassment in Cape Town, but then they do the same thing in Johannesburg. How will that be traced if it was informally mediated? So we need to tighten up that system and see how we can pursue it. I think when it concerns young people, because there's the incentive of evading a criminal conviction and a criminal record that comes with it, one tends to be a bit more sympathetic when it concerns a young person. But I think we must also be consistent, and there must be accurate records, so that if this person comes before the courts again and is accused of a similar offence, that we need to think twice about informal mediation.
Just on accountability, you also say that you are in support, I should say, of the NDPP presenting to Parliament reasons, for example, in cases on why state officials are either prosecuted or not. Explain why that is such a necessary means of oversight, if you will.
The situation at present is that the prosecution policy directives requires that a prosecutor that wants to pursue a case against a state official needs permission from his or her superior. That's sort of the short version of it. So the net effect is that it's easier not to prosecute a state official because you don't need that permission. And that's a real incentive to evade and have less work and say, well, I finalized the case. So it is not so much the cases that are prosecuted that is the problem. It's the cases that are not prosecuted that is the problem. And we think there should be greater transparency around that. And we submit that it's the duty of the prosecution service to report to Parliament, especially when these are serious cases. We are not saying that Parliament must intervene, but Parliament must be kept abreast of the reasons and whether the reasons to not prosecute are in line with the prosecution policy as well as other legislation and directives.
Quick final question, Professor Muntingh. Let's talk about the NPA, because like many other important arms of the law enforcement and justice system in the country, it is desperately short of cash. How do you imagine that is going to hinder its work going forward, especially when we have this growing caseload from state capture, just from what we've seen in COVID-19 spending this year? That too is going to add.
I think the first thing is we need to prioritize. The system is very often filled with cases that do not necessarily pose a threat to public safety. So let's prioritize those cases that will have a real impact on public safety. And that means that we need to think a bit differently on how we apply resources. The second issue is in pursuit of the state capture prosecutions, there are assets that can be seized and forfeited to the state. So yes, there is an incentive to pursue those cases if it brings money into the state coffers, and even if it's in an indirect manner, fund the services of the NPA.
All right. Professor Lukas Muntingh from the Africa Criminal Justice Reform, thank you so much for speaking to us tonight.